I and the Labour Party support the second reading of this bill.
I call the honourable member, Dr. Kennedy Graham.
Thank you, Mr. Speaker. I don't intend to take up too much time in this reading. I'll reserve my more substantive comments on the bill to the third reading. But just to say that the Green Party is very pleased with the progress in the Privileges Committee on this bill. And I do also want to join others in acknowledging the work of officials, particularly Mary Harris and Deborah Angus and Mapara Poata. It's a privilege, if you'll allow the word, to be a member of the committee served by officials of that calibre. The Parliamentary Privilege Bill is the most massive piece of work, and it focuses on the most fundamental matters affecting the Constitution, I think, that we have undertaken, certainly in the 50th Parliament, and possibly for some time before. And it also involves, I think, the most intricate threads of reasoning that I have experienced in committee work in my time in the House. And I pay tribute to colleagues Chris Finlayson and David Parker, Grant Robertson and others, as well as the officials, for collaboratively producing this bill. I just want to make one or 2 points of a general nature. We've been talking this morning about the principle of comity underpinning this bill and the relationship between the executive and the judiciary. I would wish to emphasise that, and I'm sure I speak for others, that the bill is not intended in any way as a sign or a gesture of disrespect to the judiciary. It is taking on some of the judicial decisions that have been made. As David Parker has said, there's fundamental reason for that. The principle of comity rests on mutual respect, and it is that is driving, to some extent, this bill. But there is, if I may say so, a related principle, and that is almost the principle of self-respect of the branches of government. Self-respect by the legislature of the legislature and the interests of the legislature. Self-respect by the judiciary of the status and interests of the judiciary itself. And I think the mutuality that underpins the principle of comity rests on a recognition of the need for self-respect on both branches as well. And I think it's very important that when this bill, presuming it passes through the House, is embraced in that spirit by everybody in New Zealand and all branches of government. My second point, to pick up on something that the Attorney-General had said about parliamentary privilege, I totally agree. The privilege in this House is not a licence. It's not a licence granted to members, to insiders, to defame members of the public outside. It's precisely the opposite. It's not a licence, it's a protection. It's a protection that's exercised by the representatives who are elected by the people to ensure that the rights and the freedoms of the people are respected in perpetuity. So privilege is actually, in a sense, vicariously the privilege of every member of the New Zealand society. And provided it is exercised with responsibility, then we should all be embracing it. And with privilege, of course, comes obligation, and not least the obligation to ensure that we get this bill right. I would just want to make one last comment, and that is in response to, at the risk of wafting into seminar-like ratiocination, but I blame David Parker for this. It's David's fault. It is true that bills of this nature underpin and secure the democracy that prevails in this country. But I also think and it is incumbent on us to cherish and celebrate the status of democracy in this country. But I think there's a equal counter requirement on our parts not to overstate that and not to perceive our democracy as being superior to others. And I think, in fact, the moment we start to do that is the moment we start to take on a risk that you could undermine it. And I say that because the Westminster model that Mr. Parker mentioned, which we have inherited, has tremendous strengths. But I personally think it also carries with it some weaknesses. I worked in an organisation, Mr. Speaker, that you might possibly be aware of, when I was in New York. And my job was to relate to parliamentarians around the world and to parliaments. And when you visit 30 or 40 parliaments, you get a feel for not the constitutional structures that underpin the politics and the society in those countries, but also the dynamics and the chemistry day to day that give the blood to the veins of that kind of particular democracy. And you go away thinking that, concluding that every democracy has its strengths and its weaknesses, and we have to recognise that ours have our weaknesses. I think that we talk about the separation of powers, but we've just devoted the last couple of sessions with the, not so much the SIS and the police bill, but the Henry report on exactly this issue, the separation of powers, and the problems that the merger of executive and legislature in the Westminster system gives to us. And I think we could have regard to actually the Republican constitutional status and the civil law code, which have strengths that we lack. Simple as that. And I think if we look at 30 or 40 parliaments around the world that reflect the Republican status, the one defining conclusion I have drawn from visiting 30 or 40 of them is that a little bit of carpentry is quite not a bad idea for democracy, because those legislatures are hemispherical, and the Westminster system is almost World War I trench warfare. And there are times when I have concerns looking at the fine Member of Parliament, and I really mean that in the form of Grant Robertson, and the fine Member of Parliament in the form of the Attorney General. And they're two sword lengths apart, more or less. And it is trench warfare, and it undermines the ability to form a social consensus that can be sometimes quite critical to issues of defining importance, where we must play down the adversarial nature of relationships between parties and the differentiation of policy between parties, because some things are too important for politics, and we need to find an underlying consensus on which we can base a national policy that can move marginally from government to government, but not in the fundamental way that can happen in Westminster systems, Australia, New Zealand, probably more than anywhere else. And I go through Europe, as I did at the end of last year, and I see the underlying consensus. Take climate change, which I'm devoting a lot of time to. There is a consensus there on which policy can rest, which is lacking in this country and Australia and Canada and the United States. So I just mentioned that in passing, because I think when it comes to supporting a bill like this, it's critically important that we do and that we get it right. But let us also think about some of the other broader issues of defending the democracy that we do so cherish in this country. Thank you.
Okay. Mr. Speaker.
I call the Honourable Minister